Heading for final disposal item 1, 1st April 34 of 2025, along with item 2, 3, 4.
There are 4 references. For enhancement of the and the reference was there. In the reference, the enhancement was done, but without any reason, and that too very less. And our trade is in the present of it that enhancement is to be done on the basis of exhibit and the evidence against it in behalf of the
Initially, what was the rate fixed?
Initially,
Is a common evidence of all the cases or different evidences?
all the cases
In all the cases, there is common evidence or different evidence?
common.
Common evidence. There are 4
There
more
are-
matters of yours listed today.
Or not limitation.
That is under the heading for
15/16 कॉमन जजमेंट
उसका भी इसी के साथ एडजस्टमेंट। रिकॉर्ड इसका जो है उसका भी वही है। अदर साइड कहाँ है उसका? अदर साइड कौन है उसका?
की तरफ से हम हैं उनके जैसे।
अच्छा। और ओपी तिवारी? हाँ?
संजय कुमार
ओपी तिवारी बोल रहे हैं।
serial number 2 और 3
Serial number 15 to 17 में Mr. O.P. प्रकाश तिवारी
15, 16, 17 उसका भी एक कॉमन जजमेंट है। ये कॉमन जजमेंट, हाउ मेनी केसेस आर देयर? 1, 2, 3, 4, 5, 6, 7, 8 9 है, 8 हम काउंट किए। नहीं ये इम्प्यूट ऑर्डर में भी 8 है। 1, 2, 3, 4, 5, 6, 7, 8 केस है कॉमन ऑर्डर। 9 केस नहीं है। और 8 cases are on board today? No, there are 4 more cases. 4 है उसमें 3 है।
इसमें 3 है 15 से 17
Item 15 to 17.
Yes, और 1 to 4.
7 cases are on board. इसमें 8 cases हैं, 7 cases are on board today. Just tell me. I am taking up FA number 34 of 25. What was the compensation awarded? This is under old act or new act? What was the awarded compensation?
Awarded compensation is 88,690.
88, 0, 00, 619.
88,694 per decimal.
Just a moment.
And
88, 694 per decimal.
88,694
Okay. It has been enhanced to?
to 1 lakh per decimal.
The reference was made under section.
I beg pardon.
Reference under section.
Reference under section 64.
So you say this enhancement is without any basis.
Yes. Because the
Is ad hoc and without appreciating the material summary.
of the documentary as well as oral evidence.
What was the circle rate?
And then some is with the
Circle rate. What was the circle rate?
dates.
Circle rate. What was the circle rate?
Circle rate. Circle rate has not been mentioned anywhere. The document filed by them or the document filed by us.
Not mentioned anywhere.
No.
Yeah, 2035.
They are not to the
So, what all documents do you want to refer to for enhancement?
also exhibit 1, 2 and 3. Those are the cell dates.
Exhibit 1,
2 and 3.
2. There is exhibit 1 by 1, 1 by 2 and 1 by 2.
Yes.
Exhibit 1, 1 by 1
1 by 2.
and 1 by 2 for enhancement.
I mean,
Are they referring to the same Moza?
Moja Kochara.
Are they referring to the same Moza? All the
Yes,
three
yes,
settings?
in all the 7 cases, 8 cases, we have-
I am not saying that. These three saints, do
Yes,
they relate to the
Kochara,
same Moza?
Yes, yes.
What is the name of the Moza? Name of Moza?
Kochara.
Pochara. P-O-C-H-A-R-A.
P-O-C-H-A-R.
District?
District of
Ramgarh.
District of
How much land was acquired?
in the present case is 4 districts.
Rajendra.
These 5 districts with regard to
5 districts. The chart is given in page number 4.
yes. Page number 4 of the day.
What is the date of notification under section 11?
Date of notification is 20th of August 2018.
2018. And you have produced the SETI of 2016, 2018 and 2017. Correct? Okay. What was the rate with respect to exhibit 1? Exhibit 1 per ton.
is
Rate in exhibit 1.
for 4 districts 10,12,000.
Give me the rate per decimal.
Date.
Rate.
Yes, well, I am giving the details. Date is
Right.
24th of
I am not asking the date, I am asking the rate. Rate, what is the rate per decimal by an exhibit 1?
Exhibit 1 का 2,53,000 है
एक इसमें
per decimal.
253
Per decimal.
per decimal. And exhibit 1 by 1?
1 by 1, 2,73,750.
273,750 per decimal. And exhibit 2, 1 by 2?
Exhibit 1 by 2, 2,25,000 per decimal.
225. Then how the learned court has
Yes. This exhibit, with regard to the exhibit, no discussion by the reference group.
you read para 11?
Para 11, 12, I am reading that para 11 and 12. I find that payment have claimed compensation at an unset at the rate of 2 crore 60 lakhs per acre for the acquired land. I find that the state has paid the compensation at the rate of rupees 88 lakhs 69,400 per acre. The claimants have claimed enhanced compensation on the ground of proximity or connecting roads, use, potentiality of the land for future use, nature of the land, other salaries. Certain salaries have also been proved on behalf of the claimant. It has been submitted on behalf of the opposing party that the compensation has been decided in accordance with law, taking in view of all relevant consideration, and claimants do not deserve to be granted compensation at an advance. On the basis of the above discussion, considering all the facts, taking into consideration the scientific provision as well as settled law, and the fact that no such safe formula can be applied for determining the value of the acquired land, I came to the conclusion that the average rate of land in the said locality for determination of compensation should be enhanced to rupees 1 crore per acre from 88 lakh 69,200 per acre as determined by the land acquisition office is directed to the level. And before that, also with regard to the what was the value of the exhibits, one by one and one by two, and the deposition of PW1 and PW2 has not been considered. It is mentioned that what has been filed and what is the exhibit. And the issue has been fixed at para 5. Only one issue, whether the compensation awarded to the petitioner should be enhanced. That's all.
Where is the state? There is no adjudication. Yes? There is no adjudication. So what is to be done? The point is that these CTs etc. have not been considered. Neither oral nor documentary evidence have been considered. Absolutely perfunctory order. What kind of judgment is this? Who is this officer? नाम बताइए ना. Sorry? क्या करना है बताइए?
But at page, internal page 10 of the, here the line, that is the best I can ask. Burden to prove entitlement to receive higher compensation health primarily lies on the claimant. They have relied upon certain sale leads matter, and on the basis of it, the runner could have enhanced it from 88 lakhs to 1 crore.
It is not the basis. There is no calculation. There is no consideration. It's an ad hoc increase. It is not based on that. Because these three, one is 253, 2,53,000. Other is 2,73,750 per decimal. The third one is 2,25,000 per decimal. So average भी लेने से तो as per that average is to be taken, isn't it?
But then we have to say, what is the distance between that plot of land and the present land matter? Proximity.
In the proximity, we do not know what are the evidences. It is in the same mausa.
It is the same.
It is in the same mausa, and as per the provision of the act, if you see this, and आपका वो आपने circle rate भी नहीं है इसमें. There are three modes. There are three modes. As per section 26, किताब दीजिए भैया. साहब लोग को किताब दीजिए. पढ़िए section 26. What is the mode of calculation?
Determination of market value of land by collector. The collector shall adopt the following criteria in assessing and determining the market value of the land. Namely, the market value is any specified in the Stamp Act in 99.
That is a circle rate.
So that 88 lakhs were decided by the collector.
No, that has been decided, but what is the basis of that decision? उसके बाद next, the average sale price.
Sale price of the similar type of land situated in the nearest village or the nearest vicinity.
Nearest vicinity or nearest village भी चलेगा. Right? Third देखिए.
Consented amount of compensation.
Consented तो है नहीं.
Consented to है.
Explanation 1 देखिए.
The average sale price referred to in clause B shall be determined taking into account the sale lease or the agreements to sell registered for similar type of area in the near village or near vicinity area during immediately preceding 3 years of the year in which such acquisition of land is proposed to be.
तो preceding 3 years का लेना है. उसका average. तो इनका date of notification check कर लीजिए. 28/2018. ठीक है. इन्होंने जो 3 सेल लीड प्रोड्यूस किया है वो किस पीरियड से?
16, 17 and 18.
सब तीनों प्रीसीडिंग 3 इयर्स के अंदर है. बस इन तीनों का एवरेज ले लेना. और क्या करना? 20/8/18 का है. Exhibit B. Exhibit B is the attested notification. Exhibit C क्या है? Declaration. What is this declaration?
सेक्शन 19 में जो डिक्लेरेशन
Section 19.
Application of declaration and summary of rehabilitation and police.
नहीं, notification we have to it is to be referred to section 11 का notification.
तो प्रिलिमिनरी नोटिफिकेशन इसका 1 ईयर के अंदर यदि नहीं होगा तो इलेक्ट कर इसलिए
हाँ, section 11 का ही notification से चलता है.
हां सिलेक्शन 11 सही मतलब है.
Section 11 का ही जैसे it
हाँ.
is equivalent to section 4 notification.
हां लेकिन you already said कोई रिगार्डिंग सी तो डिक्लेरेशन का नोटिफिकेशन.
हाँ, तो वो तो होगा बाद का
हाँ, बाद
notification.
का, वो बाद का.
Exhibit B is the section 11.
हां सेक्शन
Right. Exhibit B is section 11
हाँ,
and
exactly.
all the 3 sale deeds are within 3 years. तो बस एवरेज होना चाहिए था. अडॉप्ट कैसे हो जाए? काफी है, इतना ही खाली कर देते हैं. और क्या करें बताइए? इसको रिमाइंड करके क्या करेंगे बताइए?
रिमांडे का
नहीं क्यों करें?
So he has not discussed the
This is co-extensive. फर्स्ट अपील तो साथ साथ चलता है ना, इसमें तो क्या ही करना है. अननेसेसरी लोगों को परेशान करके क्या होगा बताइए? इन तीनों सैलरी का एवरेज कर देते हैं, कहाँ है तीनों सैलरी? This is 4 decimal and 3 decimal. Notification under section 11(1) is 2818. Declaration under section 19 is 63. इतना एवरेज से तो आप खुश हो जाइएगा, बताइए।
Let it be remanded, so because none of the issues have been discussed.
क्या डिसाइड करना है और क्या इशू है इसमें, बताइए। इसके अलावा यू सी इट सेज सर्कल रेट और एवरेज 3 years previous, राइट, और कंसेंट्रेट रेट। कंसेंट्रेट का तो स्टोरी नहीं है, सर्कल रेट से आप लोग डिसाइड किए होंगे
Yes, we have discussed on this.
ऑन द बेसिस ऑफ सर्कल रेट, whichever is higher you just
I
say
am not here presented the three cell lists which are on the higher side. We
Yes.
can obtain cell certificate from the office of the sub registrar.
कहाँ से आप कहाँ तो कुछ भी नहीं प्रोड्यूस किए, you should have produced,
We should have.
you have not produced,
That's
so आप
why-
रिमांड किस
Therefore,
कुछ रिमांड
because we are fixing it on the higher side. That would again be against the taxpayers.
What? No, 1 लाख रुपए कहाँ से करें? 1 करोड़ की 1 लाख कहाँ से करें? From where? Out of the blue. You see, under the new act, there is a set parameter.
So much. We can.
एक 2 + 2 4 जैसा फॉर्मूला दिया हुआ है।
I have got your losses mind, but
एक केस में किए नहीं है।
relying upon only 3 cell lists which have been presented by the claimant.
आपको कौन मना किया था सेल एग्जिबिट कराने?
Before I was playing for one
No,
more
no,
possibility, so let it be remanded, we can produce it there. Because we lost it.
This is कोई opportunity, आपको कोई मना किया था क्या सेल?
We lost it clearly, my finally it is the taxpayers' money. It cannot be allowed to be.
What do you mean taxpayers money? उसका तो जमीन चला गया, जान चली गई, आप taxpayer का money
Yeah,
का
but since जमीन चला गया, we have a short term, but it cannot be given to the.
No, you were also given opportunity to examine witnesses, right? You have exhibited the attested copy of award of DLO, right?
In fact, an impact of the has also been discussed.
डॉक्यूमेंट का भी डॉक्यूमेंट का या एविडेंस का कोई एविडेंस डिस्कस नहीं,
हाँ तो कोई बात नहीं, तो फर्स्ट अपील है ना, हम लोग तो सब कुछ डिस्कस कर सकते हैं।
क्योंकि क्या
रिमांड करने के लिए रिमांड थोड़ी होता है।
क्या विटनेसेस कहे हैं, कहीं कुछ नहीं लिखा हुआ है, कुछ नहीं है।
क्या
और
कहें?
और डॉक्यूमेंट
आप बताइए ना क्या कहें, जो आप ही बता दीजिए इनके अगेंस्ट में क्या क्या है। रिमांड नहीं होगा, सब यहाँ पर वहाँ पे तमाशा करने के लिए
We do not want the issue linger for time immemorial.
और इसमें मान लीजिए हम लोग का जो नहीं है कि तक ही है जिसका एविडेंस का देना चाहिए था भैया।
कुछ नहीं, आपने तो इनको क्रॉस एग्जामिन भी ढंग से कुछ भी नहीं किया, कुछ भी नहीं, तो फिर बस एवरेज निकाल के कर देना है। आप क्या करना है, मतलब आप एक, आप ऐसे सोचिए कि आपका अपना जमीन है, तो आप क्या करिए?
मैं ऐसे मान लेता this is a continuation matter. Permit us to file additional documents.
नहीं, एडिशनल डॉक्यूमेंट्स आप तो एनहांसमेंट के अगेंस्ट में आए भी नहीं है, हम आपको क्या परमिट करेंगे?
इसी में हम लोग एडिशनल एविडेंस
वो एडिशनल एविडेंस आपका रिजेक्ट भी कर देंगे क्योंकि देयर इज नो रीजन
कर दिया था कि हम लोग मौका दिया जाए।
कोई मौका का कोई बात नहीं। 3 डीड प्रोड्यूस किए हैं, 3 डीड पर खुद भी आपका क्रॉस
क्योंकि
एग्जामिनेशन
सर्किल रेट वाला भी जो डॉक्यूमेंट नहीं
कुछ भी नहीं।
कम से कम एटलीस्ट जो सर्किल रेट का
देखिए
है
होगा, पता है क्या, देखिए सर्कल रेट का डॉक्यूमेंट से कुछ नहीं होने वाला है क्योंकि द एक्ट इटसेल्फ सेज, द एक्ट आपने किस बेसिस पे उसको अवार्ड किया है वो भी नहीं एग्जिबिट किया है।
वही तो हम लोग
That is also not justified.
Certainly, you see, no, let us say, you had to adduce evidence to justify the compensation which you have awarded.
88 lakhs and all.
88 lakhs, उसका क्या document produce किया? Even that is not there on record.
And what is the rationale behind enhancing it to 1 crore? That is also not there.
That's what he is saying, that there is no rationale and my documents have not been considered. And you are not agreed by enhancement.
No, we are not.
You are not agreed by an enhancement.
Therefore, we
इसलिए
have
आप
to come-
1 करोड़ पर तो के कम का तो कोई सवाल ही नहीं उठता।
Is it from the also not agreeable?
क्रॉस अपील नहीं है।
Agreeable?
सिंस देयर नो क्रॉस अपील तो हम लोग
कोई
करते
क्रॉस
We
अपील
have
नहीं
to
है,
draw a
कुछ नहीं।
conclusion that we are not agreed.
हाँ, so you are not agreed. So therefore average
लेकिन हुजूर
कुछ नहीं आप तो
लेकिन इसमें जजमेंट में तो
क्या जजमेंट,
कोई डिस्कशन ही नहीं है।
कोई बात नहीं, हम लोग करेंगे ना, सब डिस्कशन करेंगे, सारा ओरल एविडेंस, क्रॉस एग्जामिनेशन, एवरीथिंग। You see, remand is not a matter of courts. If every material is there before the first appellate court, we will decide.
It is your lordship's matter, but it is not a matter of course. But your lordship will see that the AGP has failed in his duty. That
Who has paid this?
AGP. The AGP was conducting the case before
So
the
it was your case.
Yes, it was my case.
The AGP is not fighting the case.
No, it's not, but,
You are fighting.
but it cannot be allowed to get away with it.
लेकिन यहाँ पर इस केस में पर्टिकुलरली इन दिस केस हम जनरली नहीं करते, लेकिन इसमें रिमांड करेंगे।
नहीं
क्योंकि
तो
जजमेंट इसमें इतना जजमेंट पास करना थोड़ा
क्या 3 सेल डीड है अनडिस्प्यूटेड।
Your lordship may say it should be decided within a period of 12
I will decide it. इतना हैरेसमेंट किसी को नहीं कर
Your
सकता।
lordship will differ with because on this basis we are also finding it difficult to defend.
There is no discussion. Enhancement भी कम में किया है।
So since the order is cryptic,
Therefore first appeal में पूरा discussion of evidence.
in that case your lordship will allow us to bring on record certain
कुछ नहीं, why should I? Why should I permit you to do all that? Why should I permit you to do all that?
प्रोसीड्यूर की अथॉरिटी जो है ले अथॉरिटी जो है सेक्शन 60 में दो नोट बाउंड बाय द प्रोसीड्यूर ले डाउन अंडर द सीपीसी, लेकिन जहाँ जो प्रोविजन है उसमें तो है सारा चीज प्रोविजन, वो भी प्रोविजन फॉलो नहीं हुआ सेक्शन 60 में।
Entire procedure as laid down under section 60 does not.
Where is your petition for enhancement of reference? Where is the letter of reference? आपको कितना दिया था वहाँ पर 88
8,69,000.
क्या बोलना है मिस्टर मेहता?
विथ रिगार्ड टू सर्कल रेट जो कह रहे हैं उसका कहीं पर प्रूफ नहीं है, नो एविडेंस विथ रिगार्ड टू दैट, एंड देयर इज a judgment of the Supreme Court that circle rate cannot be considered when the deeds are
No. वो तो 84 उसमें 94 वाले जजमेंट में होगा ना, मतलब पुराना एक्ट में होगा ना.
नहीं
That is as per the act only. That if the circle rate is there and if the deeds are there, तीनों में से दोनों में से जो higher होगा वो लेना.
And the deposition on behalf of them has said nothing. ये कहा है कि दोनों गांव बगल में सटा हुआ है, रामगढ़ और रामगढ़ के दूसरे केस में हम लोग का सबमिशन था और we have not filed any document that they have given 2,69,000 per decision with regard to Sunil Boda's case. If all the three deeds can be considered, then it is coming to average, it is coming to more than 2,55,000 or like so.
आपका केस अगर हम मेरिट में कंसिडर करेंगे ना तो हो सकता है रिजेक्ट कर, रिमांड कर. आई विल नॉट से ऑन व्हाट ग्राउंड कैन इट बी रिजेक्टेड, बट बताएं नहीं बताएंगे.
If the matter will be remanded back, then they have to pay the interest also.
They will pay interest. So they are ready to do so. They are ready for it.
And at the same time,
बहुत बड़ा कैच है जो हम बोलना नहीं चाहते. I do not want to give lead to the respondent.
at the same time, I want to, it is having the small piece of land, and they have to sit somewhere. And the land acquired.
अच्छा आप एक बात बताइए, इतना आपका लैंड एक्विजिशन में प्रैक्टिस है, आप बताइए आप क्या सोच रहे हैं?
Since the matter is before my lord, that is in the tax and law, therefore, in first of all, my lord can really decide the matter. And the,
Did you accept the amount with protest or without protest?
That has come on page 8 of that.
Did you accept the amount with protest or without protest?
That is my
And if you do not accept the amount with protest, what is the consequence?
it has been accepted with protest.
Kहाँ?
Therefore
Sir,
reference has been made.
just a
Reference,
moment.
I cannot go
Where
for
is-
reference.
Where is it?
Reference is to be
Where-
made by the district land acquisition officer.
Where is it that the amount was accepted with protest?
On the
That is
contrary,
not
on the contrary, our WS was that they have accepted without protest, that has come in.
No, there is no such thing.
It is, yes, it is there. It is there, compensation amount without any protest and objection.
It is there mentioned, they have not produced any document.
But that was not been denied.
And
Did you say
until
that you received the amount with protest? एक statement दिखाइए ना, एक statement दिखाइए, one statement, नहीं है.
But until unless I will not object about the amount, the matter cannot be referred. I must have, there are
I
four
do not
reasons
know.
for referring the matter under section 64. One is
तो
apportionment.
इसीलिए हम जो बेस डॉक्यूमेंट है वही खोज रहे हैं, कहाँ है? Where is that document of reference? It is not there in the LC. वो खोज रहे नहीं है. सर हम रिमाइंड कर देते हैं. It requires an adjudication. आपका प्रोटेस्ट है नहीं है क्या किए हैं नहीं कर पाएंगे. Protest is a very important aspect.
No, my lord, until unless, otherwise I may be permitted to read section 64.
Yes,
Which
yes.
is- which is
Please
not-
read section 64. It talks about protest.
Yes, it is. Any
पढ़िए पढ़िए. पढ़िए. Who has not accepted the award?
We have accepted the amount, but whether it is, if we have accepted the amount, then there is no question to make the reference.
But I don't know.
And we have not approached, we cannot approach. It is the district land acquisition officer who can send the reference.
So that is why you see we are just examining it.
तो इनको तो करना चाहिए था शुरू से कि the reference is bad.
बोला ही तो है.
नहीं इसमें बोलने से वहाँ पर ही करना चाहिए था, उसके केस में आना
तो
चाहिए था,
रेफरेंस इज
reference
बैड
ऐसे
तो
करती है।
कोर्ट में बोलेंगे ना रेफरेंस इज बैड. कहाँ बोलेंगे रेफरेंस इज
When
बैड?
the reference has been made by the district land
Right.
acquisition officer, you have to come in the read.
ओ
कि
वहाँ
reference
नहीं
is
बोल
bad.
सकते थे कि रेफरेंस इज बैड. कोर्ट में नहीं बोल सकते. रिट पिटीशन फाइल करना.
Once I have submitted before the jurisdiction of the court, I cannot say now.
No, you have to say that you accepted the amount under.
No, with regard to them, I am saying, if they appear there, और इन्होंने कहा कि they have contested and 1 लाख रुपए हो गया, उसके अगेंस्ट में भी कोई क्रॉस अपील है नहीं.
तो नहीं है.
1 करोड़ रुपए हो गया, उसके बाद भी कोई क्रॉस अपील नहीं है.
क्रॉस अपील नहीं.
So that means they
और कोई एडजुडिकेशन भी नहीं. एडहॉक है. एडहॉक अमाउंट.
एडजुडिकेशन भी नहीं है कहीं
कोई
भी.
एडजुडिकेशन भी नहीं है.
तो they have not-
दोनों के केस का रेस्पेक्टिव केसेस का कोई डिस्कशन नहीं है इन द फाइंडिंग्स. ना ओरल ना डॉक्यूमेंट्री nor the respective case of the parties have been discussed.
we have made the claim that
So रिमांड कर देते हैं. नहीं तो हम बता रहे हैं हम आपको अपील यहीं पे डिस्कस करें.
we have made the claim that with regard to the Sunil Munda's case, Ramgarh, you have made payment of 2 crore 69 lakh. Therefore, we are intended and
सर आप हमारे मेन कोर क्वेश्चन का जवाब नहीं दे. इन योर एविडेंस और इन योर स्टेटमेंट एनीवेयर show me that you accepted the amount under protest.
लिमिटेशन से
Sure, limitation है और
लिमिटेशन का ग्राउंड नहीं दिया और लिमिटेशन 1 का रेफरेंस लिखा है. बात के बारे में इसमें रेफरेंस ही नहीं है. कलेक्टर से बात करता है. कलेक्टर से बात 20 का 20 बना हुआ है. 2020 राउंड से दिया हुआ नहीं है लिमिटेशन.
Calculate within 6 weeks.
सर इसको रिमाइंड कर देते हैं. बहुत कहानी है इसमें.
yes, yeah,
Para 2 of
deposition of applicant research term number Gunasala यह कि विपक्षी द्वारा मेरे अधिग्रही भूमि का मुआवजा उस समय के प्रत्येक बाजार मूल्य से बहुत कम निर्धारित किया है, जिस पर मुझे व अन्य रैयतों का आपत्ति है। इसलिए सभी रैयत मुआवजे बढ़ाने का केस दायर नहीं किया।
It does not say that they have accepted without protest.
You see, there are two things. आपत्ति है और award amount accept किए हैं with protest. There are two different things. Isn't it? Are they one and the same thing? And is the reference within limitation? Reference case has been instituted in 2021. Maybe we do not know when was it referred. तो नहीं पता ना, बहुत सारा पॉइंट्स इधर लिया है, लेकिन वो सब पे कोई एडजुडिकेशन नहीं, कोई एडजुडिकेशन तो है ही नहीं. दैट आल्सो यू आर आल्सो एडमिटिंग देयर इज नो एडजुडिकेशन एट ऑल. Mistake of the court नहीं.
And they have.
You see, mistake of the court, we will rectify the mistake. Mistake of the council हम लोग rectify नहीं कर सकते. Mistake of the court, we will rectify. I'll remind it. He will pass a fresh judgment. आपको interest मिलेगा. Time frame आप देते हैं, आपको दे देते हैं. We'll remind it.
And again, it will take years to do.
Why will it take years together, sir? आप बताइए कौन सा डेट को appear हुई है? हम लोग को कुछ बोलना थोड़ी है. आप बताइए कब जाइए? आप appear, ये तो एकदम cryptic order, absolutely cryptic. No discussion.
My submission, since the exhibits are there, court has not considered, it is the, my lord is the court of fact and law court. My lord can very well discuss the matter. But it is my submission.
Okay, so you want the judgment on merit. Sir, it's your absolute choice, and I'm very, very open when whatever I say. I don't find your protest while accepting the award. And if that was so, there is no problem in getting it adjudicated once again.
Well, the law says also that if the parties are receiving money, you deposit in his account only a judgment, 14 judgments are there on this one, including the Pune Municipal Corporation Act.
यहाँ तो deposit का कोई बात ही नहीं है. You have received the awarded amount. Have you not?
We have.
Then
But there was.
deposit का तो कोई मतलब नहीं है.
Until there is no protest, they cannot send the matter under section 64 for the reference. Protest means not in a specific word that we are protesting this amount, but our matter may be referred to the for the reference under section 64 of that. That means we are not satisfied with the law, although we have received. And since in another village, it is came into discussion in the judgment, at another village, adjacent Ramgarh, they have made the payment of 2.69 lakh per acre.
Adjacent village.
Yes,
From where are you saying
it
this?
is in the judgment.
Adjacent village. There are only 3 sages.
And I reading that para, page 5 of the judgment. I am reading from the middle line. 11th line. It has been further submitted that the classification of land made by the Procedural pattern of fixation of different rate because is also bad and the places for all the classes of land should be fixed on same rate, flat rate. It has been further submitted that the Kochara and Ramgarh are very close from Ramgarh town. On the north side of the acquired land in Punjab regiment, Ramgarh, and towards the south in Sikh regiment center, similar land of village Ramgarh, PS Ramgarh, district Ranchi, and district Ramgarh, Tata number has been given, 48 has been acquired by the government for construction of 4 lanes. The same road, 4-lane road from Kochara to Ramgarh. Both the land acquired for Kochara as well as Ramgarh are of the same nature. At present, the land has been acquired by The government for village number, PS number, district number, Khata number, sentence, land acquisition case number 3, award is Sunil Gunda, son of Prashant Gunda, and the amount has been fixed at rupees 8 lakh. Suggested claimant are claimed that the same are compensable for their respective acquired land. Further, it is 100 meter, 200 meter, and on the top it is mentioned that different level line 2 crore 60 lakh per acre. And it has been
कहाँ top?
here in the
Where is it at the top?
page 5 में ही लिखा हुआ है. Further, the market rate of the land acquired.
सर इम्प्यून जजमेंट से मत पढ़िए, डिपोजिशन से पढ़िए. इम्प्यून जजमेंट से क्या पढ़िए?
ये हो जो दिस इज द प्लीडिंग
ये
इज नॉट
उससे
अ
क्या?
सब्स्टिट्यूट प्लीडिंग इज नॉट अ सब्स्टिट्यूट ऑफ प्रूफ
उससे क्या?
वी आर प्लीडिंग
इम्प्यून जजमेंट का उससे थोड़ी चलेगा. शपथ पत्र. आप जो बोल रहे हैं ये सारे ये जो एग्जिबिट बोल रहे हैं केस नंबर 3 ऑफ 2018-19 एंड दिस केस नंबर 4 ऑफ 2018-19 these cases इसका एग्जिबिट किए हैं. आप कितना एग्जिबिट
May I see the LCR member? Because client is there in the court and he has asked.
1.5 घंटा से क्या कर रहे हैं?
Then they have received the amount with protest. What they are saying.
बताइए ये रहा है. जैसे 1894 का वो लैंड एक्विजिशन है.
It is not there in this because it is the reference.
मिला सर आपको प्रोटेस्ट?
Collector record the payment voucher. Payment voucher.
Receiving and without protest.
Without protest नहीं लिखा हुआ है.
नहीं, it does not say anything.
Nothing has been mentioned.
9,71,000 रुपये पाया.
उसमें प्रोटेस्ट की बात नहीं लिखा है कि पाया प्रोटेस्ट है या नहीं।
अंदर लिखा है.
उसको मालूम नेगेटिव है तो नो, पॉजिटिव है तो
इसमें विदाउट प्रोटेस्ट लिखना पड़ेगा क्या उनको? प्रोटेस्ट है तो प्रोटेस्ट लिखना पड़ेगा, अदरवाइज तो रिसीविंग होगा सिंपल सिस्टम।
माना जाएगा प्रोटेस्ट नहीं।
Whenever any amount is
ये भी
received,
तो माना जाएगा, but it is my submission. That's यदि प्रोटेस्ट नहीं है तो सेक्शन 60 पर रेफरेंस करेगा तो definitely there was protest, therefore the matter has been sent for reference.
लैंड एक्विजिशन एक्ट में कहाँ है अंडर प्रोटेस्ट रिसीव करने का प्रोविजन सेक्शन?
In the new act it is not there, in the old act also it is not there.
Old act it is there that who has not accepted the award by written application may file an application to the collector for
For
reference.
identification under section 18 of
Yes.
that.
But there are judgments, no, which says that if the amount is accepted without protest,
My lord, it is in another act.
which act?
Specific mention.
Which act?
Requisition and acquisition of human property. You have to mention the protest. And in all the cases, section 81B of the act says that the matter will be referred to the arbitrator when the award has not been received or received under protest.
Where is that? Oh, act is there.
Under section 8 of the requisition, in the same book, my lord, it is page 125.
Section?
Under section 8, where any property is requisitioned compensation required under this act, there shall be paid notices of the amount of which shall be determined in manner and in accordance with principle, where the amount of compensation can be fixed by agreement. Shall be paid in accordance with such agreement. We have no such agreement. Whether I have mentioned as procedural, when there is no agreement, then the matter is to be referred to the arbiter.
That's right, that is a separate thing.
And
Protest का बात इसमें कहाँ लिखी?
protest what is there?
That is in the rules. There has to be specific protest under this act. But under the LA Act also and under this 2013 Act also, there is no such provision. The language is the same. Any person interested who has not accepted the award may by written application to the collector require the matter to be referred to the collector for determination by the court. Whether his objection be to the measurement of land, the amount of compensation, the person to whom it is payable.
Under section 18 of the act.
Under
In
section.
the old act. And in the new act, there is no such.
So you want to say that there is nothing on record to show that the amount was accepted without any protest. And one of the witnesses has said that the amount was received without protest, with protest.
Therefore, matter has been referred by the DLO to the reference to the section 60.
And rest you want that since the materials are here before this court, the case should be decided on this. इनका एक विटनेस एग्जामिन हुआ है ना? आपका एक विटनेस एग्जामिन हुआ है? आपका एक गवाह भी प्रोटेस्ट के बारे में कुछ नहीं बोला. Your sole witness has not stated a word about protest. आप अपने उसमें तो बोले लेकिन आपके विटनेस ने कहीं नहीं बोला. Not stated anywhere. है आपके पास एविडेंस? पढ़िए.
So and so,
आप पढ़ लीजिए, हम तो पढ़ लीजिए.
that was one of the.
ये दिखाइए. जो कलेक्टर ने अवार्ड बनाया उसका डेट क्या है? कलेक्टर का अवार्ड
नहीं, जो रेफर किए सो रेफर किए जिस दिन तारीख को
नहीं, रेफर का नहीं बात कर रहे हैं.
और ये वार्ड 2020
कलेक्टर का अवार्ड का.
हाँ कलेक्टर का अवार्ड
You see, he has received
Para 3,
the award on 3/10/20 by DT dated 17/9/20, and before the district land acquisition officer for referring the matter, the petition was filed on 17/7/20. Correct? अवार्ड लेने के पहले ही उन्होंने ऑब्जेक्शन फाइल कर दिया. You want to have a look? ऑब्जेक्शन फाइल कर दिया. देखिए इन्होंने इनको अपने डीडी से पेमेंट किया है 17/9/20 को. जगदीश राम इन्होंने रिसीव किया है 3/10/20 को. हाँ दिया हुआ है ये ठीक है. उसके बाद जो डिस्ट्रिक्ट लैंड एक्विजिशन ऑफिसर के पास जो एलआर केस इन्होंने फाइल किया है, इंस्टीट्यूट तो जरूर हुआ है 21 में, लेकिन एफिडेविट एक्सेट्रा इज 17/7/2020. सत्रह 7/20 को फाइल कर दिया. रेफरेंस कभी भी हुआ हो. तो अवार्ड लेने के पहले उन्होंने फाइल कर दिया अपना ऑब्जेक्शन. यू वांट टू सी? देखिए आपको 3 फ्लैग दे रहे हैं, देखिए. अवार्ड इनको मिला है, इन्होंने रिसीव किया है 3/10/20 को. इनका प्रोटेस्ट जो फाइल हुआ है 17/7/20 को फाइल हुआ. अवार्ड प्रिपेयर पहले हुआ है, लेकिन डीडी जो इनको मिला है, जो इन्होंने एक्सेप्ट किया है 3/10/20 को एक्सेप्ट किया.
अवार्ड से ना कैलकुलेट होगा. अवार्ड के बाद अगर अवार्ड जिस दिन बना है, अवार्ड से असंतुष्ट होंगे तभी तो भेजा जाएगा.
उसके पहले ही प्रोटेस्ट कर दिए, यही तो बोल रहे हैं. जिस दिन इन्होंने पैसा लिया है उसके पहले प्रोटेस्ट फाइल हुआ. 20/7/20 को फाइल हुआ. ये रहा 17/7/20 का है और 20/7/20 को फाइल हुआ. और उसके पहले वाला पेज देखिए. इसका और कितना रिकॉर्ड यही है टोटल. सबका डेट ऑफ डिक्लेरेशन अलग अलग है ना, डेट ऑफ डिक्लेरेशन सबका अलग अलग।
इसमें कलेक्टर्स का अवार्ड ही नहीं है, वो तो अवार्ड जो है सो रेफरेंस अथॉरिटी का और जो पेमेंट पहुंचे जो भी है, लेकिन एक्ट में तो कलेक्टर्स अवार्ड के बारे में बोलता है।
हाँ तो कलेक्टर्स अवार्ड की बात करते हैं,
तो
क्योंकि वो जो एप्लीकेशन तो कलेक्टर के पास फाइल किए हैं,
हाँ
वो कलेक्टर उसके बाद रेफर किए हैं,
हाँ रेफर किए हैं,
तो
लेकिन
रिसीव करने के पहले ही वो फाइल किए हैं।
हाँ फाइल किए हैं, लेकिन
तो
अवार्ड कब बनाई हम करना चाहते हैं।
उससे क्या लेना देना,
अवार्ड
बात
से-
ये है कि जिस दिन वो पैसा उठाए हैं उसके पहले उन्होंने प्रोटेस्ट फाइल कर दिया।
लेकिन ये करना है, इसमें लिखना है ये limitation if the person making it was present or represented before the collector at the time when he made his award within 6 weeks from the date of collector's award. In other cases, within 6 weeks of the receipt of notice from the collector under section 21 or within 6 months from the date. For limitation we award
क्या है इसमें लिमिटेशन, उनको तो अवार्ड ही बाद में मिला है,
awarded amount का
अवार्डेड अमाउंट बाद में मिला है।
Award
एंड
तो-
ही हैज सेड सो कि जैसे ही हमको 37 का नोटिस मिला हम अपना प्रोटेस्ट फाइल कर रहे हैं। दिस इज हिज प्लीडिंग ओनली, as he received a notice and then he filed the case, it is there, and you see he has annexed a copy of the notice also 37(2). ठीक है, ये आपका नोटिस है,
हाँ,
देखिए डेट है इसमें,
हाँ 30 में तो
अरे भाई डेट भी नहीं है, देखिए अपने ऑफिसर का देखिए, आप बिना डेट के नोटिस देते हैं फिर लिमिटेशन का बात करते हैं। अनडेटेड नोटिस,
केस नंबर
वो 37 का जैसे नोटिस मिला है उन्होंने ऑब्जेक्शन फाइल कर दिया, सिंपल। यही है ना, डेट इज नॉट देयर। अब एक एक केस का कहानी सुनाइए, चलिए सब केस का एक ही स्टोरी है लेकिन डेट ऑफ एक्विजिशन अलग अलग है, सेम है। कौन सा केस किस एलआर केस से अराइज करता है ये बताइए। विच केस इज अराइजिंग फ्रॉम विच एलआर केस, लिस्ट दिखाइए सर। FA number 34 of 25 is from LR case number.
3 of 21.
Case number
83 of 2021.
83 of 21. उसके बाद FA number
34 of 2021.
60 of 25. 82 of 21. Then FA number 231 of 25. 87 of 21. उसके पहले वाला तो 82 बताए थे ना, 83, 82, 87. उसके बाद चौथा FA number of 25. This is LR number 86 of
21.
20. Notification under section 11 in all these cases is dated 18/28/2018.
दोनों एलए केसेस करते हैं, वहाँ भी एलए हम करते हैं।
LR केस, ये सब LR केस है।
लेकिन सब लिखते हैं एलए लिखते हैं।
नहीं, वो LR केस बनता है वहाँ पर डिस्ट्रिक्ट लैंड एक्विजिशन के पास, और यहाँ बनता है लैंड एक्विजिशन LR केस। अच्छा, यहाँ पर भी LR केस।
दोनों एक ही किए हुए हैं, इसीलिए हम पर और
नहीं नहीं, ये डिस्ट्रिक्ट लैंड एक्विजिशन ऑफिसर के पास से फाइल किया। एक लैंड रेफरेंस केस नंबर है 83। यहाँ नंबर डाल देते हैं, लेकिन पिटीशन तो फाइल होता है डिस्ट्रिक्ट लैंड एक्विजिशन ऑफिसर के पास, उसके बाद आके यहाँ नंबर पड़ता है।
मतलब एलए रहता है, मतलब उनके यहाँ कलेक्टर के यहाँ वही एलए रहता है, इनके यहाँ भी एलए ही रहता है। यहाँ एलआर रहता तो
ये जगदीश राम का केस से मेन केस कर ले। जगदीश राम, दिस इज 82 वाला, सबका स्टोरी तो सेम है। वो तो चार्ट में ही लिखा हुआ है
जी।
Heard the learned counsels appearing on behalf of the parties. The learned counsel for the appellant in all these cases submit that these cases arise from land acquisition case number 5 of 2018, all of which were required under the provision of right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Within bracket, hereinafter referred to as the Act of 2013. He has submitted that different awards were prepared and the matter was referred to the Principal District Judge cum LARRA Hazaribagh. For determination of compensation for the acquired land. He has further submitted that the corresponding LR case and the first appeal are as under. दो कॉलम बनाएंगे. FA number 34 of 25 corresponding है LR case number 83 of 21. FA number 60 of 25 corresponding है LR case number 82 of 21. FA number 231 of 25 corresponding is LR case number 87 of 21. FA number 232 of 25 corresponding is LR case number 86 of 21. The learned counsel has referred to the impugned judgment and has submitted that the area acquired with respect to the various persons have been mentioned therein, and all the land is of the same village, namely Pochra. POCHI. He has submitted that the learned counsel has submitted that since all the cases were adjudicated by common judgment and common evidences have been placed on record, therefore he has referred to the records relating to LR case number 82 of 21 and has submitted that the same would be sufficient for the purposes of other cases as well, in view of the fact that identical pleadings are there in all the cases. The learned counsel submits that as per the petition which was filed before the District Land Acquisition Officer Ramgarh on 17/7/2020, it was specifically mentioned therein that the opposite party served notice under section 37 within bracket 2 of the aforesaid Act of 2013, and the claimant being the interested person, claimant/awardee being the interested person, filed their claim under section 64 of the aforesaid Act seeking higher compensation. The notice issued under section 37 within bracket 2 has been annexed along with the said petition filed before the District Land Acquisition Officer. However, the said notice is undated. but it was mentioned in the said notice that the claimant should appear on 25/6/2020 to accept the awarded amount, failing which no further interest will be paid. He has further submitted that the records reveal that the payment was accepted by the claimant on 3/10/2020, while DT dated 17/9/2020, and the petition seeking higher amount of compensation has been filed while petition dated 17/7/2020 before the District Land Acquisition Officer. The Learned Counsel has referred to the impugned judgment and has submitted that the parties participated in the proceedings and the point for determination was whether the compensation awarded to the petitioner should be enhanced. He submits that 2 witnesses were examined on behalf of the claimants, namely Bhubaneswar Ram and Meena Vishwas, and 3 sale deeds were exhibited. That is Exhibit 1, certified copy of deed number 1635 dated 8/8/2016. Exhibit 1/1, certified copy of deed number 773 dated 26/6/2018. Exhibit 1/2, that is certified copy of deed number 1593 dated 21/12/2017. All the sale deeds were within 3 years from the date of notification under section 11 and were with respect to the same village. He has prepared a chart with respect to calculation per decimal of land with respect to each of the exhibits, which is as follows. The Learned Counsel further submits that the respondent also produced both oral and documentary evidence before the court. Only 1 witness was examined and following documents were exhibited. Exhibit A attested copies of awards received from District Land Acquisition Officer Ramgarh. Exhibit B attested copy of notification number 378/LA dated 28/2018, which is the notification under section 11. Exhibit C attested copy of declaration number 140/LA dated 6/3/2020, which is the declaration under section 19. And Exhibit D, which is the attested copy of the map received from District Land Acquisition Officer Ramgarh. He submits that the learned court, by passing the impugned judgment, has mentioned the case of the respective parties as per their claim and show cause, and mentioned the evidences, oral/document placed on record. However, the finding has been recorded only in paragraph 11 and 12, which does not discuss either oral or documentary evidences placed on record by either parties. he has submitted that though the learned court has enhanced the compensation from rupees 88,69,400 per acre, but 400 per acre to rupees 1 crore per acre, but the but there is no discussion of any oral and documentary evidence, and if the sale deeds which were placed on record by the claimants were taken into consideration, the compensation would be much higher amount. Paragraph 11 and 12 of the aforesaid judgment of the improved judgment is quoted as under. The Learned Counsel has referred to section 64 of the aforesaid Act of 2013 and has submitted that there are 3 modes for determination of compensation under section, not section 64. He has referred to section 26 of the aforesaid Act of 2013 and has submitted that there are 3 modes for determination of compensation, which includes A. Circle rate, B. Average sale price of similar type of land situated in the nearest village or nearest vicinity area, or C. Consented amount of compensation as agreed, whichever is higher. The Learned Counsel has submitted that the sale deeds which were produced by the claimants before the Learned Court were not taken care of by the collector, and having been exhibited before the court ought to have been taken into consideration for the purposes of determination of market value of the land. He has further submitted that as per explanation 2 of section 26, it has been provided that for determining the average sale price referred to in explanation 1, 1/2 of the total number of sale deeds or the agreements to sale in which highest sale price has been mentioned shall be taken into account. We have submitted that out of the 3 sale deeds which were produced, if half is to be taken into consideration, then 2 of the sale deeds of the highest value should be taken into consideration, and the average of the same should be considered for determining the market value. But this exercise has not been undertaken by the Learned Court, and the Learned Court has enhanced the compensation to rupees 1 crore on ad hoc basis, and there is no adjudication by the Learned Court. The Learned Counsel has also submitted that since the first appeal is a continuation of the suit, and therefore the materials are already before this court, he submits that appropriate judgment be passed so that the compensation, so that the market value of the land is ultimately determined on the basis of materials which were produced before the Learned Court. That's all. That's all. The Learned Counsel for the state has opposed the prayer and has submitted that if the the Learned Counsel for the state has submitted that oppose the prayer बाद में, है ना, has submitted that so far as the impugned judgment is concerned, it is not in dispute that there is no adjudication as such. The entire discussion is in paragraph 11 and 12, which does not refer to any oral or documentary evidence. He has also submitted that under such circumstances, the matter be remanded to the court concerned for fresh consideration. And this court may not enter into the merits of the matter. The learned counsel has also submitted that a plea was raised by the state that the amount was accepted without any protest, but such plea has not been considered by the learned court, and therefore it requires adjudication. यही आपको बोलना और कुछ बोलना और क्या बोलिएगा बोलिए.
रहेगा तो क्या जो रहेगा.
The learned, in response, the learned counsel for the appellants had submitted that the records of the case itself reveal that prior to accepting the awarded amount, the petition was filed before the land acquisition officer raising protest with respect to the quantum of compensation. And the sale deeds which have been exhibited were also mentioned in the protest. He has also submitted that the land acquisition officer was satisfied that the award was received under protest, and therefore, in exercise of statutory powers under the Act of 2013, he referred the matter to the learned court for adjudication, and it was for the learned court to adjudicate the matter on merits after appreciating the materials on the court. That's all. Concluded. ये भी करने से हमको डर लगता है. So huge task.
डिमांड वाला
It did not come from us. We have prayed for that matter to be demanded.
You have not prayed for that the matter be
It
demanded.
did not come from us.
It will not come. They are not saying that it is remanded. आप बोलिए तो नहीं लिखाएंगे आपका. They are not saying. They say that it should be decided here only. Am I correct, Mr. Mehta?
Right.
They are, rather they have been opposing to the nail कि remand ने आपका बहुत submission हटा दें कि remand करना.
हम लोग ऐसे कि without any protest
बस इतना वो तो हम लिखा ही दिया आपका. That's all. लिखा है कि नहीं remand का बात आपका जैसा बोलिए. ठीक.
actually उसी का ही केस.
थोड़ा सा फेयरनेस दिखाइए.
हाँ तो हम फेयरनेस हम
थोड़ा सा फेयरनेस. एक ही जमीन
फिफ्टी ऑर्डर तुम लोग कह रहे हैं
क्रिप्टिक ऑर्डर और जो सेल डीड प्रोड्यूस किया उसका क्या?
तो उसका डिस्कशन होना चाहिए. इफेक्ट ऑफ एविडेंस
इसका प्रॉक्सिमिटी है रोड से.
That is not the law under 2013.
ठीक है उस पर हम नहीं जा रहे हैं. लेकिन
2013 में the measure and the manner of fixation of compensation has been changed substantially. Same area का सेल डीड्स रहेगा जितना 3 years में आता है उसका हाफ सेल डीड्स को एवरेज लेकर दे देगा.
26 के एम्बिट में भी रहेगा तब कुछ इफेक्ट ऑफ एनी इंपैक्ट ऑफ एविडेंस कहीं डेल्ट नहीं है. यहाँ उसी से है तो उस केस में बगल में मिला है ये है कहीं एविडेंस है
उसी जमीन का है मतलब वही
यूनिवर्सिटी हेडलाइन सेल एग्जीक्यूट हुआ. सेल कहाँ का है क्या है कहीं नहीं ऑर्डर जजमेंट.
कोई बात नहीं. अच्छा केस में लड़िए. सब केस में लड़के क्या करेंगे.
ठीक.
अब देखते हैं ऑर्डर कर लेते हैं. ऑर्डर को रिजर्व कर लेते हैं. ठीक है. इसी से भी ना द लर्नड काउंसिल हैज आल्सो argued the case from the records of LR case number 82 of 21.
अगर एक्सेप्टेंस ऑफ डीटी जो है that may vary in every
तो आप हमको बताइए ना.
और एप्लीकेशन भी अलग होगा.
तो आप बताइए. You tell us. ये काम हमारा थोड़ी है. आप ही बताइएगा ना. तो क्या कोई और दिन रख दें.
एक दिन रख दिया.
हाँ
एक दिन रख दिया. हम लोग देख लेते हैं सबका
मंडे को रख दिया.
अन्य बात है हम लोग ले लेते हैं इसे हम लोग ले लेते हैं कैंडिडेट ले लेते हैं
ठीक है ट्राई कंक्लूड मत करिए Pose this case for at the request of the learned counsel for the
हम
state.
लोग बता रहे हैं कहाँ सेंटेंस
Pose this case for further hearing on next Thursday. पाथर्ड है फर्स्ट केस रहेगा हाँ उसमें क्या है इसी के साथ कौन सा है आप हैं इसमें मिस्टर तिवारी मिस्टर एम के रॉय 15, 16, 17 आइए है फॉर कॉन्डोनेशन ऑफ डिले
66 में है 106
106 days सीरियल 15 दूसरे में 106 days और तीसरा और ये जो हम लोग कंट्रोल किए थे वो भी तो इतना ही
डिले कॉन्डम तो उसी दिन रख देगा।
हाँ उसी दिन लिखिए FA नंबर 66 और 25 67 और 25 एंड 68 और 25 आइए सीकिंग कॉन्डोनेशन ऑफ डिले इज कंडोन वो स्टैंडर्ड ऑर्डर है ठीक है और टैग दीज केसेस विथ FA नंबर 34 और 25 and post on next Thursday for final discussion.
सब एक साथ है
सब एक साथ। हाँ आइए अलग एडमिट कर लीजिए सहारा का क्या होगा
वही we have
हो गया आप लोग रिप्लाई फाइल कर दिए
certified copies have been
नहीं मिला
only will
ये
only a date may be fixed for
you have find your response yesterday you got what
yesterday we received study
so
ऑर्डर होने के बाद भी
now according to me the proper procedure would be in terms of even if this is taken to be a partially an order of remand where the lordship had fixed for additional evidence and for deciding a particular issue, then they can only additionally pray for certain grounds under order 41/26. They can add to the ground which they have already taken. Not otherwise they cannot challenge that order anywhere. They have to challenge it before your lordship by framing additional ground.
that's right if they want
That is all.
so additional ground होगा तो क्या होगा you do whatever I just do not know whatever what is the now the next course Mr. Vishal Tiwari is here
Lordship, in this case, Lordship, we have received this hard copy DFA study. I have sent it to my office, that is Lordship at Lucknow. Now some proceeding in NCLT is there, Lordship. We have to see who is the authorized person to swear the affidavit in now. For that purpose, Lordship, I am just seeking 3 weeks time. So that Lordship, we can, whatever we want, we will do in the meantime. And thereafter, Lordship, the argument can start.
you see the operating person is the only authorized officer इसमें क्या seek instruction करना है
Lordship knows better, Lordship, but since
Yes.
we have sent the things,
the operating agency is the only authorized person
Yes,
इसमें
sir.
क्या आपको further
they
आपको क्या
have,
करना
they
है
have not received the original copy yet, Lordship.
you
and
see
by-
there are direction of the honorable supreme court इसको हम ना इस तरह
नहीं
से
नहीं हम जरा भी नहीं कह रहे
तो
not on
क्या
that
है?
point only if anything is to be filed Lordship who is the person who will be coming because Lordship knows what is happening in the company only for that matter
I don't know what is happening
It is
उसको क्या पता
widely known here
According to me, for additional ground, it is not required to be affidavit. Only advocates.
the application has to be filed with an affidavit
Sorry?
as far as my instruction my
Additional
knowledge
grounds.
is any IA is to be filed by an affidavit without affidavit how an advocate can file
But the
What by-
order 41/26 only says that additional grounds have to be pleaded. That's all.
Order
Grounds have to be,
41?
41,
27 that is an application Lordship that is by way of an IA every day Lordship we are
That's
filing by
right.
way of IA yes
so order 41 rule 26
27
27 you want to file an application to this
some
you do
rebuttal-
whatever
yes
you if you want to do you also do yes respondents
No,
whatever you want to file to this additional evidence which has come up or this order
May
is just
I
come
read
up.
only order 41/26 may I read?
नहीं तो करना
ये
भाई आपको
सिर्फ-
जो मर्जी करिए.
नहीं सिर्फ ये लिखा
अच्छा,
है this
आज-
is ground no IA is required so therefore no affidavit is required. That is only my content.
Some
इसमें
documents
कोई
are
एफिडेविट पे करना चाहता है तो इसमें आपको क्या परेशानी है?
No, ठीक है but they since they if they cannot seek 3 weeks time and 4 weeks time.
तो लंबा टाइम तो क्या करना है?
Lordship may grant any time, but what is my problem, what is my difficulty, Lordship, that only I am stating with this on you. I have to be practical. I cannot say by tomorrow I'll do it. In other cases, Lordship,
And how about you all? You are also willing to do something about it?
Yes, we will be filing petitions.
What petition?
Challenging interim orders. There are 2 orders wherein our petitions were rejected. We will be challenging those orders.
Before this court. So when did you do it?
Yesterday we received the certified copies.
But you never informed me that you are not getting the
no,
certified
Lordship,
copy.
the last occasion, since Lordship, how it has happened, in the trial court itself, Lordship, the order was never uploaded. Only and soon.
No, that we know.
Yes,
but on
yes.
the last date, it was specifically observed
Yes.
that you will get the certified copy.
That was just the last week, Lordship. By preparing everything, Lordship, it was done. The office has also done it very hurriedly. They have given it day for yesterday and probably they have got yesterday. Only last week it was there. Last Thursday it was there.
The learned counsel for the parties have submitted that the certified copy of the order passed by the learned court has been received by them only yesterday/day before yesterday. By way of last indulgence, they are granted time to do the needful by 12th of May, post on 13th.
And Lordship, other documents also we require that way.
I do not know.
Yes.
आपको जो मर्जी आप करो.
And that is sufficient time.
Yes, sir.
कौन वाला? हाँ